Doctrine of UltraVires. Ultra means beyond and wires means power. Altogether, UltraVires means beyond the power. Any act that lie beyond the authority of a company to perform is known as UltraVires. UltraVires are divided into this following. UltraVires, the Companies Act, the Memorandum of Association, and Articles of Association. Let's look into detail. UltraVires, the Companies Act, which means that any act done contrary to or in excess of the scope of activity of Companies Act will be ultra-vires. Such an act is void and cannot be ratified even by unanimous resolution of all shareholders. This means that even if all the shareholders agree that the thing will be valid, it will not be valid. It is void and cannot be ratified. For example, if board members are appointed or removed without following statutory provision, even if all shareholders approve, also it cannot be ratified. It is void because you see, it is in excess of the scope of activity of Companies Act. It also declares a provision contained in the memorandum, articles, or agreement or resolution is void if it is repugnant to any of the provisions of Companies Act. Repugnant means in conflict or incompatible with. Ultra-vires Memorandum of Association, also called MOA, is a document listing out the constitution of a company. So it contains clauses detailing the boundaries of the company's activities and its relation with the outside world. Okay, the in MOA contains object clause. Section 4, Clause 1, Subclause C of Companies Act 2013 requires every company to state in their MOA the objects for which the company is proposed to be incorporated and any matters considered necessary in furtherance thereof. So, okay, think company as a house. There is a wall around our house. That wall is memorandum of association. It is the boundary beyond which we cannot go. So our object should be clearly stated in the MOA, which is Memorandum of Association, so for which the company is proposed to be incorporated and any matter considered necessary therewith. Okay. A company cannot do anything which is beyond the purview of object clause. Means like I said, the company is a house and there is a wall around it. We cannot do anything beyond that wall. So that may be another people's property. We only have access to our property. So it will be contrary to the object clause. Okay. Whatever is not stated in the memorandum as objects or powers is prohibited by doctrine of UltraVires. Anything done beyond the act is void and cannot be ratified, like I said earlier. UltraVires, the AOA or UltraVires Article of Association. The articles of the association of a company shall contain the bylaws and regulation for the management of the internal affairs of the company. It plays a vital role in governing a company's affairs and also defines the rights of its members inter se. Inter se is a legal maxim meaning among or between themselves. So, act which are ultra vires the AOA, but intra vires the MOA, which means that outside the scope of articles, but within the powers confirmed by the memorandum, will be ultra vires AOA. But it is also void. But the company in general meeting may alter its article by a special resolution and ratify those unauthorized acts. Okay, special resolution of all shareholders. This rule is meant to protect shareholders and the creditors of the company. This ultravires doctrine of ultravires is meant to protect the shareholders and creditors of the company. On the famous, let's look into the famous case law, Ashbury Railway Carriage and Iron Co. Limited versus Ritchie. The object of the said company was the object for which the company is established are to make and sell or lend or hire railway plans to carry on business of mechanical engineers and general contractors. What was the case? We can see the company, the Ashbury Railway, the company entered into a contract with Miss Ritchie to finance the construction of railway line in Belgium. Okay, and further, subsequently, the Ashbury Railway repudiated the contract on the grounds of its being ultra vires. But Miss Ritchie brought a case for damages on the ground of breach of contract. As according to Ritchie, the word general contractors in the object clause gave power to the company to enter in such a contract. and there it was within the powers of company. The contract was ratified by majority of shareholders. At the final, the House of Lords held that the contract was ultra the company. So therefore, it is null and void, as I said earlier. Even if every shareholder of the company had in the room and said that this is a contract which we desire to make, which we authorize the directors to make, still it will be ultra. The shareholders cannot ratify such a contract. As the contract was ultra-vires object clause, it's ultra-vires the MOA. I said earlier, MOA is the boundary beyond which we cannot go. Okay, the contract here was beyond the MOA because the contract was to finance the construction of railway line, which is not mentioned in the memorandum of association, which is ultra-vires object clause. However, the House of Lords also, in other cases, said that held that doctrine of ultra-vires should be applied reasonably, and unless it is expressly prohibited, a company may do any act which is necessary for or incidentally to the attainment of its object, uh, unless it is expressly prohibited by the Companies Act. If the Companies Act is expressly not prohibited thing, which can be and it is necessary for incidental to the attainment of its object, a company may do that act, which is not ultra. However, even when the matters considered necessary in furtherance of the objects are not stated, they would be allowed by the principle of reasonable construction of the memorandum. Okay. Okay. Loan borrowings, guarantees, and ultra-vires rule. An ultra-vire borrowing does not create relationship of debtor and creditor. Okay. How will we know whether a transaction is ultra-vires the company or not? Okay. There are three steps. By these three steps, we can decide if the transaction falls within the objects, within the memorandum of association, within the boundary, then it is not ultra-vires, hence not void. If it is outside the capacity or the objects of the company, it is ultra-vires. And if the transaction is excess or abusive of the company's power, it is ultra-vires. And the transaction will be set aside. Even the shareholders cannot ratify the or cannot validate those activities outside the scope of the company itself. Implied powers. The powers exercisable by a company are to be confined to the objects specified in the memorandum. But there are some powers which are implied. Okay, which powers which are implied, such as to appoint and act through agents, to borrow and give security, also power to sell. There are all implied powers. Okay, okay, which need not be specified in the memorandum. These implied powers. Okay, we can look into power which are not implied. It is prudent to include them expressly in the object clause. Okay, some points are there. Okay, these are the powers which are not implied. We have to specifically include them in the object clause. Acquiring any business similar to company's own business, it is not implied power. We need a shareholders approval and all. It should be within the power of MOA, AOA, within the power of Companies Act. Entering into agreement with other persons, joint venture, or other arrangement. Very clear powers are necessary to justify such transaction. Or taking shares in other company having similar objects. Taking share of other such investment authorized doing indirectly is that okay, what is it? Taking shares of other company where such investment authorizes the doing indirectly, that which will not be intra-wise if done directly. Such things should be expressly stated in the objects. Okay, promoting other companies or helping them financially, it's also not implied. You have to expressly state in the MOA, in the object clause. Power to sell and dispose the whole of a company's undertaking, to use fund for political purpose, power to give gifts, donation, charities not relating to objects stated in the memorandum. It should be specifically stated. Acting as surety or guarantor should be mentioned. Okay, we can look to what are the shareholders' right in respect of ultra-vires act. A shareholder can get back the money paid by him in an ultra-vires allotment of shares. But a transfer of that share from him would not have been so allowed. Only the shareholder himself can get back the money of ultra-wise allotment of shares. Effect of ultra-wise transaction. Void ab initio. Okay, the ultra-wise transaction is void from the beginning. Void ab initio means void from the beginning. Company is not bound by this act and cannot sue or be sued upon. And the ultra-wise transaction cannot become intra-wise by reason of estoppel or ratification. The shareholders cannot ratify an ultra-wise act. Injunction. The members can an injunction to restrain a company wherein ultra-wise act or is about to undertaken. Restrain means prevent someone or something from doing something. The members can get an injunction to restrain a company where ultra-wise is undertaken. Okay, what are the personal liability of directors in an ultra-wise transaction? Let's see. It is one of the duties of directors to ensure that corporate capital is used only for legitimate business. Okay. If it is diverted to some other purpose which is outside the memorandum or company's power, the director will be personally liable to replace it. It is duties of directors, one of the duties of director to ensure that. Okay, a shareholder can maintain an action against those directors to compel them to restore the funds of the company which was employed in ultra-wise transaction that they have no authority to enter into without making the company a party to suit. So, if it is a ultra-wise transaction is company is entering into a ultra-wise transaction, the directors are personally liable without making the company a party to suit, which means that the company have no liability, the directors have the liability to restore the fund which was employed in ultra-wise transaction. Okay, in case of deliberate misapplication, criminal action can also be taken for fraud. What is deliberate misapplication? It is a type of fraud that involves intentional misuse or misapplication of an organization, resource, or asset. In such a case, criminal action can also be taken for fraud. Okay, what is then? Uh, Okay. Earlier I said that the shareholders can go for suit and maintain an action to restore the fund. The shareholder also can like protect the directors. If where the director exceeds their authority, the same may be ratified by passing a resolution in general body meeting of shareholders, provided the company has the capacity to do that as per its memorandum of association. Okay. If a director exceeds the authority or enter into an ultra-wise transaction, the shareholders can ratify it, provided it should be within the capacity of the company, which means within the um, memorandum of association. This is let's see this. Company's money has been used to ultra-wise to acquire some property. Okay, ultra-wise transaction has entered to acquire some property. The company's right over such property is held secure. And company will be the right party to protect the property. This is because it represents the money of the company. Even it is ultra-wise transaction, it is the money of the company. So company is the right owner to it. Ultra-wise borrowing does not create relationship of creditor and debtor. Earlier I said that does not create the relationship of creditor of debtor. Ultra-wire tort. Company not liable for torts committed outside its object. In order to make the company liable for the torts or crime of its employee, it will have to be proved that to be proved the tort was committed in a course of activity purview of company's memorandum, and it was committed by the employee within the course of employment. Then the company may be uh, held liable, which depend upon the how you prove it. Ultra-wise grants and guarantees. Directors cannot make an unauthorized grant. Directors cannot make an unauthorized grant unless object is to promote prosperity of company or it is incidental to the objective. Okay, a guarantee for payment of dividend enables action against company reimbursement even when there are no profits. Such an act is ultra-wise and void. Payments of we know that dividend is paid when there is profit. Guarantee for payment of dividends which enables uh, the company should give me profit even when there is no profit. That's not fair. Such an alt is ultra vires and void. Okay. What are the exceptions to the doctrine of ultra vires? Or any act which is performed irregularly but otherwise it is intra-biased the company can be validated by shareholders by the company giving consent to the general meeting. Like I said earlier, the directors don't have power, but the shareholder can validate in the general meeting, provided the company should have the power within the scope of memorandum. And the second thing I said was some acts are deemed to be within the authority of company by the Companies Act 2013. They will not be considered as ultra vires even if they are not expressly stated in the MOA. Some implied powers, that is also exception. Any incidental or consequential effect of ultra vires act will not be invalid unless the Companies Act 2013 expressly prohibits such act. Any act incidental or consequential effect of the ultra vires will not be invalid unless it is expressly prohibited in the Communist Act. Okay. See, like I said earlier, any act which is outside the authority of directors of the company, but otherwise it is intra-wise to company, can be ratified by shareholders of the company. But the if it is ultra-wise the MOA, which is it is ultra-wise the MOA, then it cannot be ratified by the shareholder. If it is ultra-wise the Companies Act itself, then then it cannot be ratified and it is void. Okay, thank you.